Good morning, everyone. Good afternoon, guys. My name is Reese. I'm a licensed attorney specializing in criminal defense in the great state of Texas, guys. If you have been recently arrested or someone you know has been recently arrested in and around the Corpus Christi, Texas area, which is Nueces County, Sanpat County, around the coastal bend, and you need some legal advice, guys, please feel free to shoot me an email. I would be happy to take on a consultation. Okay, guys, with that being said, we're back here with another analysis of a written motion here. As you know, guys, I'm a full-time practicing attorney, so I'm sort of limited in I'm limited in the amount of time that I can spend on the YSL trial. I know I probably should be uploading more videos, and I'm sorry about that, guys. But like I said, I actually do practice full-time, so can't really do that. Okay, guys, with that being said, we've got the Kendrick motion to limit time of state case, and this was filed by Deamonte Kendrick on August 19th, 2024, and we're going to have a read, guys, and I'll give you my thoughts. For the most part, I'm just sort of reading, and where I think that, some analysis or some legal analysis is warranted, I will go ahead and do that. Okay, guys, motion to time limit state's case due to prosecutorial unpreparedness and inefficiency, undue delay, waste of time, and or needless presentation of cumulative evidence. So if y'all are not familiar with that last phrase, needless presentation of cumulative evidence, one of the objections that you can make under the federal rules of evidence, which most states have adopted sort of wholesale, including Georgia, is unnecessary cumulative. So you've sort of presented this evidence. This evidence is cumulative, and that's grounds for an objection. All right, the defendant, Deamonte Kendrick, by and through his undersigned counsel, who I forgot what his name was. Let me see. Let me just skip to the end here. It's Weinstein. Okay. Without waiving any other rights to which he is entitled, files this motion to time limit state's case due to prosecutorial, we've read that, stating the following. As this court has broad discretion to exercise reasonable control over the presentation of witnesses and evidence, the court should use that discretion to prevent this trial from stretching indefinitely and beyond the reaches of time due to the state's unpreparedness and inefficiency and presentation of cumulative evidence causing undue delay, poor decision-making by the jury, as well as harm to Kendrick and other defendants. Simply put, the court should put a reasonable time limit or clock on the remainder of the state's case. And Weinstein is right, guys. The judge or the court has the ability to control the court's own docket. So this case has gone on for years, and it's shocking how long this case has gone on. And yes, it's a RICO, a Racketeer Influenced and Corrupt Organizations Act case, and so there are multiple defendants and there are complex issues. But guys, if this case were brought, as many other commentators have noted, were this case brought in a federal court or even brought, frankly, by a different district attorney's office, this case would have already been resolved. Okay, as many of you are familiar, you are entitled to a speedy trial under the Constitution. And so when you get to the point where our defendants have been sitting in jail, indicted, but without the opportunity to get out on bond, guys, you're just, in my opinion, you're running into issues. So yes, he's right when he says that the judge here, Judge Whitaker, has the authority to rein in the state. And I would argue that given the fact that this is the longest case in Georgia's history, and given the fact that we know that this case would have been resolved in maybe a few months in federal court, if not shorter than that, all right, and given the fact that we know there's been repeated motions filed late by the state, inaccuracies by the state, wasting of funds by the state, delay by the state. Guys, given all of that information, yes, I agree with this motion that there should be some time limits. There should be something brought to rein in the state. I agree with that. And he's right. The court does have that authority. The state has put and continues to put this court, these defendants, and these 16 jurors through an arduous tedious journey. I like that sort of poetic language. The court should put an end to our forced march, even it's okay. Even as the state will likely contend that we should blindly trudge on in trust that the next months will be different, that the state will develop the speed and efficiency of our finest Olympic athletes, and that the finish line of their snail-like marathon is in sight. At this point in time, this honorable court has borne, and by the way, that's B-O-R-N-E, that should say B-O-R-N-E, borne witness to the state's unpreparedness and lackadaisical attitude toward any type of diligent approach to moving in a deliberate fashion toward a conclusion. But why should the state have any need to move with deliberate speed? Nice rhetorical question. The state returns home to their friends, families, and loved ones at the conclusion of each day. The state lives, it should be an it, guys. When you say the state, it shouldn't be a they, it should be an it. He's referring to the prosecutors and the district attorney. Nevertheless, guys, in the United States, the jury is an it and the state is an it. The state lives its lives, goes to work, and gets their paychecks no matter how long this trial proceeds. Meanwhile, for Kendrick and the other defendants, every day is Groundhog Day. But instead of waking up to Sonny and Cher, he wakes up to the cacophony of Rice Street and the ritual of heading to court. The U.S. Supreme Court has explained the critical role of the trial judge in a criminal case. Our cases have consistently recognized the important role the trial judge plays in the federal system of criminal justice. Quote, the judge is not a mere moderator, but is the governor of the trial for the purpose of assuring its proper conduct and of determining questions of law. A criminal trial does not unfold like a play with actors following a script. There is no scenario and can be none. The trial judge must meet situations as they arise, and to do this must have broad power to cope with the complexities and contingencies inherent in the adversary process. To this end, he may determine generally the order in which parties will adduce proof. His determination will be reviewed only for abuse of discretion. The judge may refuse to allow cumulative, repetitive, or irrelevant testimony. If truth and fairness are not to be sacrificed, the judge must exert substantial control over the proceedings. This is from Gators v. United States, 425 U.S. 80 at 86 to 87. So here, guys, we have some language from a U.S. Supreme Court opinion. And what does that mean? That is binding on everybody. That's binding on all the courts in the federal system, and it's binding on all the state courts as well. So this sort of language that the judge may refuse to allow repetitive or irrelevant testimony, that is actually the law. It is an opinion written in the United States Supreme Court, and it is the law as it applies to Georgia as well. But notice, obviously, the may refuse. So there's, this is how our law is typically written, with some amount of wiggle room, so to speak. The state, after originally proposing a witness list of over 700 witnesses, has a list of over 100 witnesses it still intends to present at trial. What specific evidence the state intends to use with each respective witness remains unclear. What specific evidence the state intends to use with each respective witness remains unclear. A very generalized description of subject matter to which each witness will testify has been provided. No end to the state's case in chief is in sight. This is simply untenable for the remaining 16 jurors or the defendants who remain jailed and without bond, and the presentation of another 100 witnesses by the state would cause undue delay, would be a waste of time, and would amount to needless presentation of cumulative evidence. As put so succinctly by the Third Circuit Court of Appeals, quote, courts need not allow parties excessive time so as to turn a trial into a circus. After all, a court's resources are finite, and a court must dispose of much litigation. In short, the litigants in a particular case do not own the court. Duquesne Light Co. v. Westinghouse, and that's a 1995 case. Just to tell y'all briefly, I think that Georgia's in the 11th Circuit Court of Appeals, not in the 3rd, for what that's worth. This honorable court, likewise, the prosecution here does not own this honorable court. This honorable court has broad discretion on the presentation of evidence and should limit the introduction of duplicative or unnecessary witnesses by the state. As noted by the Georgia Supreme Court, OCGA Section 24-6-611A2 provides the trial court with broad discretion to exercise reasonable control over the presentation of witnesses and evidence, quote, to avoid needless consumption of time. So let's just have a brief look at that. OCGA. All right. So here we have Georgia Code Section 24-6-611, and here we have the court shall exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to, 1, make the interrogation and presentation effective for the ascertainment of the truth, 2, avoid needless consumption of time, and 3, protect witnesses from harassment or undue embarrassment. And then we have the remainder of that. So he's right. That is what that stands for. And here we have Neumann v. State, Neumann v. State, 311 GA, Georgia, 83 at 93. It's a 2021 case. That's on page 93. Let's have a look at that. Okay, 311, and he's looking at page 93. Let's look for 24 dash. Let's see if it's in here. Okay. Quote, because OCGA Section 24-6-611A2 provides the trial court with, quote, broad discretion to exercise reasonable control over the presentation of witnesses and evidence to avoid needless consumption of time, we see no abuse of discretion in the trial court's decision to sustain this objection by the state. So, to briefly speak on the case that Weinstein is citing, if we go actually to the language in that particular case, this was obviously a case in which it was directed towards the defense for taking up too much time and presenting unnecessarily cumulative evidence. Whereas, as we can see here, Weinstein is applying that to the prosecution or to the state. And, you know, it's a unique circumstance because this is sort of the Fulton County District Attorney's Office leading case. It's the case that particular district attorney's office obviously clearly wants a win on, and they're going to do whatever they really can to get a win. And it's just interesting to me that the language that we're citing to, or the case to which we are citing, was aiming that dagger towards the defense, and now we're aiming it at the prosecution. We're aiming it at the state. And really, guys, the state, the district attorney's office, you got to understand, has hundreds, thousands of cases pending. They generally want to get rid of cases as fast as they come in. They want to get rid of them. So it's just a very unique and special circumstance when the district attorney's office or the prosecution does not want to get rid of a case. The Fifth Circuit, the predecessor to our 11th Circuit, has also recognized the ability of a trial court to limit the number of fact witnesses at a criminal trial where those witnesses' testimony would be cumulative. See, for example, Chapa v. United States. This is a 1919 case. Y'all don't know this, guys, but actually the Fifth Circuit used to cover Georgia, I think, back before like 1968 or something. So even though it's the Fifth Circuit, because it's 1919, it is still binding on, it's still a Georgia federal circuit. Okay. Furthermore, this court can limit evidence under Rule 403 of our state's rules of evidence. Quote, relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. Here we see Georgia Code Annotated Section 244403, which is basically a copy and paste of the Federal Rules of Evidence. Thus, there is also a basis under either Rule 611A2 or Rule 403 for this court to exercise reasonable control and discretion in placing a time limit on the state's case to prevent undue delay, waste of time, or be a needless presentation of cumulative evidence. So, one thing that I really like about Weinstein's advocacy, and I can see how it's different from Max Schartz or Brian Steele's, is you can see. Well, okay, I'll try and explain. You might not be able to see. I come from the world of civil litigation, meaning I come from the world of lawsuits. And when you're in the world of lawsuits, you've really got to argue cases, you've got to argue statutes, and a lot of this sort of fairness, due process is not really there. You're just arguing over money, contracts. Sometimes you're arguing over injunctions or family matters, but I come from the world of commercial litigation, and people don't care as much about your due process and fairness in commercial litigation, frankly, for obvious reasons. I'm not saying that's wrong. And you can tell that Weinstein sort of comes from that background in the way in which he writes. I think it sort of comes through in his writing. And judges, number one, judges typically like to avoid rulings in the first place. Number two, judges want multiple options to reach the same conclusion. So it's harder to appeal their decisions or get their decisions overturned on appeal. They want as narrow ruling as possible, and they want as many different avenues to reach the same conclusion. So, for example, if you have a relevancy objection, also throw in a substantial, a prejudicial objection as well. So here we can see not only a 403 objection, but we're looking at a 611 objection as well. So the judge can make a ruling in his client's favor through 611, through 403, or through both. Okay. Quote, "It has never been supposed that a party has an absolute right to force upon an unwilling tribunal an unending and superfluous mass of testimony limited only by its own judgment and whim." MCI Communications v. American Tel and Telco, 708 Federal 2nd, 1081 and 1171. That's a 7th Circuit 1983 case. So we're citing a lot of federal cases, which I would like to see a little bit more, again, binding case precedent. In exercising its reasonable control over the presentation of witnesses and testimony, Kendrick also urges this court to consider the ramifications of the present pace of trial and its impact on the jury, the case, as well as the defendants. While there is no doubt that the new court is moving this case along at the fastest pace possible given the court's meritorious recognition of the limited, recognized right of the state to present its case in the manner it deems best, the prospect of another 100-plus witnesses leads to several undeniable conclusions. This trial will last well into 2025 if the state is permitted unlimited time to present its case. Courts outside of Georgia and the 11th Circuit have recognized, so here we're going into persuasive argument because it's not necessarily binding precedent, have recognized the impact on a jury of a lengthy trial, a trial merit consideration. For example, as the 7th Circuit has approvingly quoted, exceedingly lengthy trials lead to reduced concentration and recollection of events on the part of all participants, particularly witnesses and jurors. In very long cases, exhaustion may diminish everyone's performance. The quality and representative nature of the jury may be reduced by the fact that many citizens, often the most competent, are unable or unwilling to take time to sit for cases lasting weeks or months. So basically what they're saying in a sort of sophisticated way is that doctors, lawyers, architects, engineers are just not going to sit on a jury panel because they don't have the time to do that, which you can take it or leave it, but that's what they're saying. Okay, I'm not gonna read through all of these block quotes. While the state puts on its case, witness by witness, Kendrick and the other defendants sit in jail, their lives on hold, the clock ticking on their lives, second by second, minute by minute, hour by hour, day by day, month by month. Meanwhile, the risk of a confused jury, unable to comprehend a years-long trial, only grows. Wherefore, Mr. Kendrick respectfully requests that this honorable court place a reasonable time limit on the amount of time that the state has remaining to put forth its case in chief. All right, guys, so I've given you a little bit of my brief analysis as I was reading, but let's look at the proposed order here. So this is what's called a proposed order. Now, what is a proposed order? A proposed order is an order that you're asking, hey, judge, this is what I want. This is what I want you to rule. And so you submit a blank copy of it to the judge. And here's how it's read. Wherefore, the defendant, having filed a motion to time limit state's case due to prosecutorial unpreparedness and inefficiency, undue delay, waste of time, and or needless presentation of cumulative evidence in the above captioned matter, it is hereby ordered that the defendant's above motion shall be set down for hearing on a date certain, to wit. Okay. All right, guys. So you want to know my thoughts on this? I think this is spot on. I think this is spot on. This is both a good argument, both from a layman or a common sense perspective, but it's also a good legal argument. The court absolutely has the power to put guardrails on the prosecution or the state's case. I do think it's ridiculous that this case could go on into the middle of 2025 with an unending, a potential stream of 100 further witnesses. So I absolutely think that this is a good motion. I think it should be granted, and I think that there should be guardrails put on. There should be guardrails put on the state's ability to endlessly pursue this case. So I agree with this motion. I hope that it's granted, and then I hope that Judge Whitaker puts some guardrails on the states so that this trial doesn't go on endlessly with 100 further witnesses. I think that's ridiculous. Okay. I appreciate you guys for watching this video. If you want to support this channel, please make sure to use the donation links in the description box below. Thank you.